Samson Lardy Anyenini is private legal practitioner, host of a news file on Joy News. We know the role he played in the right to information, one of our foremost advocates. He's joining us via phone, and Esther Hulu is Programs Manager, Commonwealth Human Rights Initiative, also joining us on phone. Dr. Winifred Nafisa Mahama, Acting Director of the Information Services Department, is with us in studio. So good morning to you, Samson. Good morning to you, Esther. Hope you're all doing well.
Fine, thanks for asking.
Great. So let me start with you, Samson. And first of all, I just would want your general thoughts about the revelations in this documentary.
Not that they are not known to me. I've been very familiar with them, and if you've monitored some of Samson's stake in 2020 to 2023, I kept, insisting that some things were being done wrong, and we needed to do some things. I had called for the Attorney General, the Information Minister, and the President all together to show that they are not complicit in discouraging the use of the RTI Act, and to publicly denounce the disgraceful conduct by officials who were doing some of these things, putting some of these stumbling blocks in our way. I actually also called for the dismissal of the heads of institutions who were embarrassing the government and giving the country such a bad name. I still believe in all of these, and I believe that the signaling is important. We must make it as a central part of the KPI, which Pidopon Nkrumah sought to have done for all the institutions which are within the public space and liable to the RTI. It must be part of their KPI that they are seen to be proactive in enabling disclosure of information for as long as it is not information that is exempt, and also for particular individuals to be held liable and to be made to pay from their pockets if they do not, comply with the request in a manner that is consistent with the law. For example, Occupy Ghana, after Sir John's will to close that, the Achimota forest had been privatized, some people had bought land, began to find information from the Lands Commission. The Lands Commission was so nonchalant in its conduct. Eventually, the matter got to the RTI Commission. They were sanctioned with 100,000. And every day that you don't pay, you are, as it were, accruing more debt. They were giving some 14 days to comply. They were not. Occupy Ghana wrote to them every day for the 14 days, just so they will do the right thing. Multimedia Group has made RTI applications, and similar, discouraging conduct has been seen on the part of, public officials who are in charge of these institutions. And I think we need to do the right thing and do it as quickly as possible. The RTI Commission, they have been very excellent, and I'm happy that they are penalizing those who are recalcitrant the way they have been doing. But very soon, Winston, the penalties are actually going to go up. That, these institutions will suffer are actually going to go up. And they'll go up in a way that I'll disclose very soon. These are just my preliminary comments. We appeared before the Subsidiary Legislating Committee in July of 2024. It was a bit late, but because of that, the rules or the regulations have not been passed. But the regulations are also very good, and they are going to be substantial and effective fines for non-complying institutions.
Okay. I'll get back to you, but let me just go to Esther now, because I realize that the Commonwealth Human Rights Initiative, you host the RTI coalition in Ghana. So ordinarily one would expect that you have easy access to information, but you've had an interesting encounter with the Ghana Police Service, and the data that Corruption Watch analyzed shows that the police service suffered a penalty of 100,000 cedis because of your complaint. Tell us about that, Esther.
Thank you very much. Good morning.
Good morning.
Okay. So, yes, you made mention that because of the work that we have done so far, you'll be thinking that you would have easy access to information. No, that is really not the case. Yes, that is really not the case. Our request to the Ghana Police Service, in fact, they were in two. We made one was on, for my organization, the Commonwealth Human Rights Initiative. One of our area is also access to justice. Mm-hmm. So we follow issues with police accountability and all that. So we did a research. I mean, we've been collating cases on police brutality and killings and all that. So we've had those cases put together, and we sent the request. I think it was in 2002. Yes, we made the request in 2002, asking about investigation in those cases, because normally when these things happen, the police will issue a statement. Yes, this happened, and we are doing an investigation and all that. So, and like I said, as an organization that works in the area, we had an interest, because of course we've been engaging and you're not getting any information as to how far things are going on those cases, and how citizens, those whose rights have been abused, are being compensated and all that. So we've been working and engaging and following up. And while we are not getting the feedback, we invoke the RTI law to access information in those areas. And as you said, we didn't get the information. In fact, our first request, we even did it, per the law, when you are doing a request, you are supposed to address it to the information officer. When we addressed it to the information officer, our letter wasn't received, because as at that time, that was 2002, like I said, as at that time, they had not put in place, they didn't have an information officer. So we sent the letter and they didn't take it. But because we also want some updates, we said, okay, even though the law insists, the law says that the letter should be addressed to an information officer, but then we said, okay, because the communication we got from them is that you should address the letter to the IGP. So we came back to the office, we addressed the letter to the IGP, and we sent the letter. And we didn't get any feedback for, per the law, within 14 days, you're supposed to get a feedback, whether even if it's a refusal or even whatever. But we didn't even get even acknowledgement of the receipt of the letter. We didn't get. So, per the law, you are supposed to, after the 14 days, if you don't get any feedback, it is deemed as refusal. So, and per the law, if it's deemed as refusal, you have the right to appeal to the head of the institution. And bear in mind, like I said, our letter was already addressed to the head of the institution anyway, because when we addressed to the information officer, the letter was rejected. So we said, okay, fine. Even though, so for us, from that time, we had the opportunity to appeal straight to the RTI commission, because that's the next line of action from the head of the institution. But we said, okay, this is an institution we work with, so let's write again to the head of the institution, but this time appealing to the head of the institution. Yes, again, we didn't get any feedback, and that was why we now wrote to the RTI commission. And then the RTI commission also wrote to them. And back and forth, the information wasn't given at the time that the RTI commission stipulated, and therefore they surcharged them that 100,000. Okay. And I think I want to make this point. One of the things that is also hanging in there, which is more like a gray area, is when the charge is given afterwards, how is the follow-up done? Because when the charge was given to the Ghana Police Service, the charge does not replace the information. Even though you are being fined, you are also supposed to pay the fine and also give the information. But as we speak now, I think the fine was given, whether 2003 or 2003. Since then,
as in 2023.
Yes, 2023. Sorry, Good. 2023. Since then, as we speak now, we have not received all the information. Although afterwards, we received some correspondence sharing some updates on some of the cases. Like I said, we enumerated, I think, almost about 20 cases. We gave detailed information as the date, the area, the region, the area, the community that this happened. So since then, we have received some of the information, but up to date, most of the information we did not receive.
Okay. And have you gone? Have you asked for those information? Have you asked for the information that you didn't receive?
Yes. So, like I said, they have written to us with some of them, and then we wrote back reminding them on the remaining ones, but we have not received. But we have not gone back to the commission, and that is where I also want the commission to also look out. Maybe the commission, because I know the commission have a monitoring department, a department that is responsible to monitor some of these things. So I'm sure the commission can also be following up on some of these institutions. I know that it has a lot of work to do, but that is one of its core mandates, monitoring. Monitoring is one of its core mandates as per the law. So I believe that the commission can also take this up and ensure that although the fine is given, following up to ensure that the information is also given. Yeah.
Great. Let me bring in, Dr. Winifred Nafisa Mahama, who is acting director of the Information Services Department. And you know that I know that the Information Services Department, you are the owners of the RTI architecture, right? What's your own assessment of compliance with the Act?
Okay, so I will just give a brief explanation on the whole administrative architecture on the implementation of the Act. You know, the Act was passed in 2019, but effective implementation started in 2020.
Yes.
So it gave some room for some administrative processes and structures to be put in place before the implementation of the Act. And so the Access to Information Division of ISD is one of such administrative structures that was put in place to look at the implementation of the Act. Within the Act, we are looking at it from 3 points of view. From the demand side, which is the people, the public asking for the information, and the supply side where we sit in, that is where we provide public the demand side with the information, that's the public institutions and all that. So at our end, we provide the technical support through our information officers or the right to information officers to assess public institutions to provide those services and also to assist them implement the part of the Act that public institutions have to. The Right to Information Commission is the ombudsman and is responsible for compliance and all that. Listening to the documentary, I realized that most of the issues raised are real and it's something that has come up. Most of the institutions who defied these happen, if I'm not wrong, between the first 3 years of implementation. As a law, and I see it as a public policy document that we are leaving. So with a new law, with public institutions and public officers used to performing or holding information in a particular way and being asked to go strictly by the law, it wasn't easy doing the sensitization, getting them to understand that public institutions are holding information in trust for the people. And so the people have a right to those information. Once I pay my tax, you pay your tax. The information generated is not for the public institution, but for the good of the general public. And so it helps in transparency and accountability to the people.
And talking about the, access to information division, I'm just interested on, the measures that you've taken to ensure the drive enforcement of the Act.
Okay, so the Act says public institutions should have information officers, information units to assessing the implementation. When the implementation began, the public institutions there was extensive stakeholder collaboration with Office of the Head of Civil Service, Public Service Commissions, Parliamentary Select Committee on Information and Communication to come out with a roadmap in the implementation of the Act. So public institutions were supposed to nominate designated officers who were trained to handle the requests that were coming in. But for a while we realized that it was being a challenge because most of the designated officers are taking up that responsibility as an added responsibility, and for many cases it was proved kind of proving to be difficult to go through. So information officers were recruited by the head of civil service, and we trained them and posted them out to public institutions for them to take up that responsibility. So we have information officers in almost all the MDAs and about 155 in the municipal, the MMDAs as we speak now. And their role is to assist the public information to go follow the requirements by law and to provide information as it be. We do the training and retraining and make sure that they go by the book. Okay. The office provides technical support to our officers who are the information officers at those institutions. So it's a day-to-day activity.
Okay, you say you have over 150 at the MMDAs.
Yes.
We have 261 of them.
Yes. So it's because we just don't send anybody. We once we get clearance to recruit, Office of the Head of Civil Service recruits, and we train. Okay. And then post out, and it's all part of.
When are you seeking to fill the remaining assemblies?
As and when we get clearance from the Ministry of Finance, because it has budgetary implication. Mm-hmm. But notwithstanding, we have information officers in virtually all the districts that's in Ghana, and so our district information officers who are in districts where we don't have RTI officers have been trained to be designated officers within those institutions. Okay. As well. Okay. And so we provide that technical back end for our officers to be able to assist the institutions to give out those information. So as the law says, your request goes through the information officer as the first level of inquiry, and then if you are not satisfied, then you write to the head of institution. And if you are still not satisfied, then it goes to the commission. And so our officers are the first line of approach when it comes to request for information.
Okay, that's Dr. Winifred Nafisa Mahama, Acting Director, Information Services Department. I still have Samson Lardy Anyenini, who is a private legal practitioner, host of Newsfile, and of course, his advocacy when it comes to right to information, and Esther Hulu, who is Programs Manager, Commonwealth Human Rights Initiative. Thank you very much for staying with us here on the Super Morning Show on Joy 99.7 FM. And this morning, following the airing of Saga over RTI, where institutions have had to pay up to 3.5 million for their refusal to adhere to a simple law. Samson Lardy Anyenini is private legal practitioner. You know him as host of Newsfile on Joy News and an advocate for the right to information. Dr. Winifred Nafisa Mahama is the acting director of the Information Services Department, and Esther Hulu is programs manager, Commonwealth Human Rights Initiative. So, Samson, let me start this one with you and find out how we can improve access to information for citizens, and also how citizens can maximize benefits from the RTI law.
Right. I need you to help me take your calculator and do some mathematics, because I suppose that is what is going to help a great deal.
Okay.
When the RTI regulations are passed. A penalty unit is 12 Ghana cedis.
Okay.
Please calculate 12 times 500,000.
500,000.
Yes, please.
That's 6 million.
That gives you 6 million. So the proposal, the feeding issues that Esther referred to, you take your application, there's a lot of delay, and sometimes you are being told that the delay is occasioned as a result of some error or mistake you have done on it, that you have failed to provide some information, and there needed to be a correction before your application can be processed, among several other things, that you have not paid your subscribed fees yet, the prescribed fees yet, and so on and so forth. And they use that to hold you back and delay almost forever. Now, the regulations, which were taken to Parliament and considered, but unfortunately could not pass, require that once the officers detect any problems with the application, they are supposed to get in touch with the applicant and ensure that there is a rectification or a correction of that application within 24 hours. Within 24 hours. And if they fail to do so, there is problem. They are also supposed, one of the other issues is, you send the application like Ernest Nogbe did in 2021, thereabouts, and he went to Electoral Commission when he was seeking, information about the purchases of some biometric devices, about the cost and the contractors involved, which the EC had to refer the application to their private lawyers, which was such a sin against the law. Instead of the information officer, they referred it to their private lawyers. And there was a whole lot of back and forth. And their lawyers gave such wrong advice. Eventually, it was the court that held that they are entitled and it will be done at a certain fee. But even that fee was exorbitant. All those kind of excuses, the law now, by the regulations, is seeking to cure them by requiring that if you fail to do that, your institution is going to be saddled with at least, at most, 6 million Ghana cedis as a fine.
Okay.
In fact, the regulation was requiring that it should be 1.250 penalty units. That would have taken to about 15 million. But together with the committee, it was agreed that should be reduced to 500 penalty units. Again, either you are paying that amount, or at the very minimum, you are going to pay about 6,250 penalty units. 6,250 penalty units. So do the math again. 12 times 6,250 penalty units. That one, the committee did not do anything to it. That is to say, they agreed. I think
that is 12 times 6,000. 1 minute. Let's.
Yeah. Now, I think 6,250.
Okay, 6,250. That is 75,000.
Right. So the other thing that is holding back the process, that held the regulations back, was that you find that in the law itself, chiefs were not made accountable for the lands and the proceeds they get from the lands, the royalties they get from various things, and for the community. The previous law had included chiefs to be liable, but we understand that previous law could not be passed because the chiefs stood against that provision. So that provision was eventually removed and the law was passed. The law made a provision allowing the minister, through a legislative instrument, to designate private, entities or institutions that will be caught by the law. In the regulations, the private institutions to be caught by the law, now it's supposed to include the national and regional houses of chiefs. But because of Article 106(3) of the Constitution, any bill that concerns, chieftaincy must first go through the chiefs for their inputs. So that has also become an issue, that even if the regulations have to be passed in their current form, the chiefs must, make their inputs. Otherwise, we expunge it.
Okay.
If we don't, then it takes us back to the 2018 situation where, because of that, the bill wasn't passed. So these are the two things I think that are standing in the way of the law now. And once it is introduced back into Parliament and passed, because of the sanctions regime directed at the institutions themselves, I believe a lot will be gained. And then the individual officers too. There is provision for gross misconduct for which they are going to be punished for. The law itself in Section 81 or 82 thereabout punishes them with about 3,000 to 6,000 Ghana cedis or 6 months to 3 years in jail for failing to do their job. But there is an extra provision in the regulations where if they slip on the job and don't do what is required of them, they can be sanctioned by way of gross misconduct.
Okay. Now, let me just find out from you, Dr. Mahama. So when it comes to the LI, I mean, Samson was talking about it. Yes, it wasn't passed in the last parliament. Where are we when it comes to the passage of that LI? Do you know the process that is leading to its passage in the current parliament?
It is yet to be lead. It's at the select committee level.
Okay.
It goes through some processes in parliament before it's lead.
Okay.
So it's at that level.
It's at that level. Well, that's all time would allow us this morning. Thank you very, very much, Samson Lardy Anyenini. Thank you also, Esther Hulu. Thank you, Dr. Winifred Nafisa Mahama. And look, all of us have a role to play, okay? So together, we can all come together in our own small way in ensuring that we're able to win the fight against corruption. Dr. Nafisa, you want to make a final point?
Yes.
Okay.
So we are all in the information sector. We are all in this climate of misinformation and disinformation. The RTI law is one that can help us, if you use it well, to curb in some way the issue of misinformation, disinformation circulating. If public institutions are proactive with information which are fact-checked because they are coming from the institutions themselves, it closes the gap of where there's no information, where people take advantage to speculate and all that. So I'm urging all public institutions to take advantage of the RTI law and make information available to the general public as a way of being transparent and accountable to the people.
Thank you very much. And you can interact with Corruption Watch on Facebook. It's Corruption Watch Ghana. On Twitter, it's Corruption Watch or at CW Ghana. Instagram, Corruption Watch _GH. And then on YouTube, Corruption Watch Ghana.